So we're on video 4 of the probate series. Remember, the series is a little bit longer because, well, the process is complicated. The probate process in California has 12 stages, basically 12 steps. As the executor is legally responsible for starting the process that will distribute all of the assets of the deceased, which includes real estate. As the appointed executor or administrator, PR, personal representative, you are required to undertake the probate proceedings through the California Probate Court system. This court system works under the Superior Court in the county in which the person lived, the deceased lived. Before any assets are distributed to the survivors, there are 12 very specific steps that must be completed in a very specific order based on your county. So please make sure that you take a look at that. Again, the forms are clear in nature, however, their language is not that simple sometimes. So you need to make sure that they're filed properly. Let's go. Step 1, file the petition. The petition must be filed in the county of residence of the deceased at the time of death. You can find this form, which is the D11-1 at the Superior Court. This will basically, the court will officially be notified and that a hearing needs to be scheduled. This hearing will take place probably within 30 to 40 days from the date that you file. If the deceased left a will, then a copy must be attached to the filing. In some cases, you may need to provide a death certificate. Step 2, the publication of the hearing notice. A notice must be published in the local newspaper minimum of 3 times. If there is a will, then every person that was named must also receive a physical copy that is mailed regarding the hearing. Additionally, all legal heirs of the deceased, whether they're mentioned in the will or not, as well as potential creditors, must receive a notice via mail. A hard copy, okay? So make sure you take care of that. Step 3, the first probate hearing. After the initial hearing, the court decides who will be the administrator of the state. In the probate petition, you can suggest who will be the administrator. This is easier when there is a will and the person was actually named. However, if the person that was named as the executor has decided that they don't want to participate, then the court will assign somebody else. Not everybody wants to take care of such a lengthy process, and not necessarily for the time of work that it requires, but for the consequences with your closest relatives. Okay, so if you once all of that is done, we move on to step 4, which is basically be prepared to pay a bond. The probate court requires the administrator to pay a bond, and that's basically telling the court that you're going to do everything that is right in order for you to take care of this probate. The court requires the payment to be done before you can actually receive the letters of testamentary, which is the letter that indicates that you are in charge. These documents grant the administrator the legal authority to proceed in handling the deceased estate. The bond prices vary, and it could be at 3% to 10% of the value of the estate. It depends also on your state and county. All of this is refundable, but it must be paid up front. Since the bond is required, it is also an expense that will be paid from the state after the funds are when the funds are distributed. So don't worry, you're not losing your money. Step 5, proving the will. Proving the will means basically that you're convincing the court that the will in question is the last wishes of the deceased person. In most cases, you have the regular will, but you had an attorney and you have 2 witnesses that saw the person sign the document. You're good to go. You could have a holographic or a handwritten will, or a printed form. We can download things from the internet and just fill in the blanks. Step 6, the collection of assets. As the state administrator, one of the most important things that you're supposed to be doing is collect all of the eligible probate assets of the deceased, which include the personal property. I have a whole list that you can just plug in. If you want to, just reach out. I'll be happy to give that to you. The items that should not be included in there are those that already have a beneficiary designated, like your 401k. If the title of ownership of the asset is held in the deceased and it requires a name change, the administrator is able to help you with those arrangements. Usually to process a transfer of title, a death certificate must be present, which is why we said you need at least 10 to 15 copies when you first get those. There is a inventory and appraisal form. Again, we have over 60 forms, which needs to be filed with the Corps by the administrator. So reach out. This form is your personal declaration that the items specified in the form are each of every asset of the deceased, so you could take care of it, and then at the end we know where that one was designated to. Step 7, the designation of a parole referee. With rare exceptions, the court will assign a parole referee or will require you to contact one on your own. So there are non-monetary assets that can be professionally evaluated. Step 8, payment to creditors. The administrator provides a notice to creditors within the formal written notice. Here's another form, notice of administration to creditors. Following is received, creditors may submit a written declaration against the state. They have, in California, 4 months to submit this. All of the expenses that you incur can be paid during this time, like the funeral arrangements. California allows you time, obviously, to report, but you must act quickly on paying all of those things up. Step 9, the second hearing. The second hearing will involve the judge deciding on the final distribution of the estate. Step 10, the sale of the real property. If real estate was owned by the deceased and it was liquidated, then you must file a report of sale and petition of the court. This is when sometimes we hear that the sale requires a court confirmation. Here's where the judge says, go ahead, you're allowed to sell it. Not all of the states require that. Step 11, payments of the taxes. Ensuring that the deceased's personal income tax returns have been filed is the number one priority. In addition to paying attorney fees, accounting fees, federal, California imposed taxes, it is very important that you, as the personal representative, you take care of this. Otherwise, you're liable on the state, and you may experience negative consequences. Step 12, closing of the estate. During the closing of the estate, the administrator provides a complete and final accounting of all of the actions that have been taken on behalf of the estates. To conclude the probate, a hearing is scheduled to report with the judge. The judge will probably require you to show all the receipts and the balances that have been paid as you were distributing the assets to the beneficiaries. When the judge is satisfied that all of the aspects of the probate have been successfully completed, then the court will discharge the administrator from his or her responsibilities. It means your job has been done. Congratulations. Any appeals to the judge must be filed within 60 days of the mailing of personal service of the entry of the judgment. As probate, it's a court supervised process, and with all of the above requirements necessary to complete, it can take anywhere from 6 months to up to 2 years. It all depends on the complexity of the state that you're handling. Important to know that all the executors are entitled to receive compensation for their time and as they were fulfilling the duties of the administrator. Also know that it's important to know that compensation is taxable income and must be filed in your federal tax returns. In California, you are entitled to receive about the same amount of payment as the attorney. If you have any questions regarding probate or you find yourself in this situation, please reach out. My team and I will be happy to assess you, help you provide you with contact information for probate attorneys. As you know, I am a probate certified specialist. I have been for many years now. So I am here to help you. I know this is a very long process, but I'm at your service. Have a great day.